a day preceding to his first appearance.
That's not correct, my lord. He seems to be forgetting that on the same day the warrant of arrest was executed. That's the copy I referred to say it is attached in the docket. We made copies for the defense. There's a warrant of arrest on the 26th of October 2020 that was executed, given to the accused.
Akusona-ke iqiniso uma ethi-ke nge-20 noma nge-26-ke ila anikezwa khona-ke i-SAP 14A lena-ke ukuthi akasayindeke ngazo lezo i-26 zika-October 2020 lezo ila manje eseboshwa khona-ke noma-ke kukhishwa kusebenza-ke le ncwadi lena-ke kwakuyisigунyaziso-ke sokuthi-ke akaboshwe le okuthiwa-ke i-warrant of arrest.
May I approach?
Yes. Well, I have a charge sheet here. It says Exhibit EE. Date of first appearance, 27/10/2020. Accused number 1 is Sibiya, number 2 is Ntanzi, number 3 is Mube, number 4 is Mapisa, number 5 is Nduli. Is this what you are referring to?
That's what I'm referring to.
Yeah, let's show the people because it appears I know the case better than some people here. Now, just show counsel also there, because according to this witness, that tallies with what this witness is saying. Not that there was an appearance in August.
My lord.
No, yeah, we're not arguing.
No, my lord,
I'm saying,
please.
wait, Mr. Ngobezulu, please. Let them show you that document and they show the others. Because this is what this witness is saying.
My lord, must I proceed with a cross-examination?
Yes.
But now, if the court is interjecting,
No, I'm not interjecting.
I'm still coming on the charge sheet, my lord. I just want to clarify these things because now the court wants to. The reason why I'm dwelling on this aspect, this is the first time to hear about the JP. I need to thoroughly consult with accused number 1 and 2 to my satisfaction so that I can proceed to cross-examine the witness, especially on the charge sheet. And there are certain parts in the docket where accused number 1 has just indicated to me that he wants to be shown a part where his thumbprint was placed on the docket.
No, fine.
Yes, my lord, can
so
I...
this court, wait. This witness is being badgered by you, saying he has repeated it 4 to 5. How many times did you say the arrest was on the 26th?
4 times, my lord.
The first appearance was on the 27th. I'm not interfering. Wait, Mr. Ngomezulu, please. I've listened to this witness. So I'm saying, where he says the first appearance was on the 27th, this document, which apparently says the first appearance was on the 27th, I've got it. The court has it. So I'm saying they must show it to you and the other counsels. That's all I'm saying.
But it's part of my cross-examination. I'm still going on exhibits. I'm still going on exhibits.
Okay, fine. Just go on, sir. No problem.
My lord, I think I would request an adjournment because if the court is disturbing my cross-examination, they are taking me out of the line.
No, I can't.
May I just stand the matter down until tomorrow?
No ways. Just continue. The court is entitled, when there is confusion between the state, the prosecution, if it has a document which contradicts that contradiction, to say, is this the document you are referring to? That's all I'm saying to this witness. Is this the charge sheet you are referring to when you say the warrant of arrest and the charge sheet were simultaneously issued?
Yes, correct.
That's what this witness is saying. Now I'm told, that's what I'm saying. I can't disturb your cross-examination. You are free to cross-examine as you want. Okay.
I'm not even satisfied with the contents of what is in this.
Which
copies.
one? No, you can.
I haven't gone through them. I still want to check with both accused. These copies are for accused number 1 and number 2. I'm talking about this JP.
No, fine. You can
yes,
go on.
May I be given an opportunity just to satisfy myself?
No, fine. Go on. Send
Please. So, perhaps, do you have a docket with you, Mr.?
Well, not with me, but it's available. It's within reach. I mean, the state has it. Not with me, but it's available, the original docket. But as I said, my lord, also, the copies were finished to the defense. We made hard copies.
The defense never read the copies. That's what Mr. Ngomezulu says. He never read the copies. I say he says the copies were finished to the defense, and I'm saying the defense never read the copies, because you are saying you want to familiarize yourself with the copies.
That's correct.
That's it, yeah.
Yes.
That's all I'm saying.
May I request this kind of questions to be stood down until tomorrow? I'll proceed with other questions so that I can familiarize with the documents. With the leave of the court.
No, Mr. Ngomezulu, just continue with your cross-examination. If you want to extend your cross-examination to tomorrow, there's no problem. You know, let me tell you normally what happens in a trial. Before counsel stands up and cross-examines a witness like this, counsel has prepared, he has read the papers, he has read the charge sheet, he has read everything. That's how I know it's being done. You read everything, so that when you cross-examine this witness, you're informed of the case you want to present to him, and you're informed of the case the state is presenting. Now you, Mr. Ngomezulu, you stand up and say, you haven't read these documents.
My Lord,
And this witness, in contradistinction, tells you what he has done.
That's
and now
correct.
we are talking at cross purposes.
My
But if
Lord,
you want to postpone the cross-examination of this witness with regards to that exigency, you can do so.
yes, but can it be clear, my Lord, that when I came on board, it was for trial within the trial.
Yeah.
Whatever that has been discovered was for the main trial. And all the witnesses that have testified during trial within the trial has never mentioned a J50 that was issued and executed against accused number 2. All those witnesses have never said that. The first time it was said by Brigadier Gininda. So hence I'm saying, I cannot take it as an ambush for what he has said. This is what he has done. I want clarity from what he has done, which has never been canvassed by either of the witnesses. That's the reason why I want to familiarize myself with this documents.
Okay, continue, Mr. Ngomezulu. No problem.
Thank you, my
Continue.
Lord. Thank you. Okay, with the leave of the court, I'll just leave it for tomorrow. I'll appreciate maybe tomorrow you bring along the docket, Mr. King.
Well, yes, I can. The docket, like I said, my lord, it's available. I don't have it here, but it's within the court building. If I'm to bring it, the original one, yes, I'll do that.
Uma kufanele ukuthi ngizeke nedocket-ke likhona-ke likho kude ngingaliletha.
My question relating to docket 636 on exhibits that the state has led you on, occurrence books, charge sheets, and other related exhibits. But what is of essence in this question relates to the occurrence book. Is there in the occurrence book of respective police stations wherein either accused number 1 or accused number 2 was booked in or out under case number 636 of 10/2014?
Well, one that I remember, my lord, in Albertine, when he was booked in for pointing out, it's clearly reflected that he was booked in for the pointing out under case 636 of 10/2014.
Umele ufuna ukwazi-ke ukuthi manje-ke la ngokumayelana nomsolo wokuqala nowesibili kukhona yini kulama OB books ebekukhulunywa ngawo lana la kubhukwe in khona na-out umsolo wokuqala bebhukwa phansi kwaleli iqala eliwu-636 lo-brigadier alikhumbulayo-ke yileli eliwu-636 la ewayokwenza khona-ke i-pointing out ibhaliwe-ke icacile lapho ukuthi u-636.
It's 636 for the first time from their date of arrest.
My lord, the accused, as I said earlier, accused 1 was arrested for a different matter. The warrant of arrest was, J50 was executed in relation to the drug dealing case of Tembisa 217 of 3/2019. he was in custody on that matter. So obviously the movement of him, it will relate to that matter until this matter becomes relevant.
Bese ngishilo ukuthi ke i-warrant eyakhishwa ke kwakuyicala ke leli dakamizwa laseThembisa elu-2173/2019 bese kuthi ke manje ke ukuhamba kwakhe ke umsolwa ke ehambela lona lelo cala ke kuze kube isikhathi la khona ke manje leli icala lona ke nalo liyavela.
Yes. On the same murder charge under a cold case. My worry in terms of the investigations prior to accused 1 and 2, including 3, 4, and 5, appearing for the first time in Boksburg Court. At that stage, there was no direct, I would say, there was no direct evidence linking. Sorry, may I rephrase this question? Sorry, I don't want to confuse the months. At the time, Sibiya was arrested on the 30th of May 2020. He was the first person to be arrested. Is that so?
He was the first person to be arrested for Tembisa case 217 of 3/2019.
Waye
Yes.
umuntu oqala uSibiya ukubosha eboshelwa icala laseThembisa.
Yes. But will you dispute about the case of Senzo Meyiwa, 636?
No, it's not in dispute, my lord. But he was also interviewed on other matters where he was also a person of interest.
Angeke ngikuphikiseke ukuthi ke yebo uma amacala
But in relation to 636, on his interrogation or interview regarding the death of Senzo Meyiwa, the state at that time had no evidence that linked accused number 1 with the death of Senzo Meyiwa.
I'm not sure, my lord, if we can say that, because what led us to him, there were fingers pointing to him that he was involved in the killing of Senzo Meyiwa, and eventually when we got to him, more evidence was found, and hence we are standing before this court. He's charged for the killing.
imibuzo mayelana necala likaSenzo Meyiwa babungekho ubufakazi ke ukuthi uyambandakanyeka ke uBrigadier ke uthi kavumelani ke nalokho ngoba ke yayikhona ke iminwe eyayikhomba kuyena ke sathi uma sifika kuyena ke sathola obunye ke ubufakazi kuyena ingakho manje simila kule nkantolo.
Now, I understand the logic of your 30th on a J50. Let me say, before he was approached by Sergeant Mohola and Sadike and Buthelezi, the state had no evidence against him until such time accused number 1 made.
There must be basis in the form of a statement or intelligence or a source saying this person committed this crime. So you can't just go and question a person when there's no basis for that person being implicated.
Angivumelani ke naloko okushoyo ukuthi kwakungekho ubufakazi ngaleso sikhathi ke kuyena ke ngoba ke angeke nje ukuthi uye emuntwini ke ube sokhulumisana naye ke ungenabo ubufakazi ke noma ke ukhona umuntu nje othe noma sikhona nje istatement
Investigating. But what I'm saying, the evidence at that time before his arrest dependent on the information of the informer. Is that so?
No, it's not what I'm saying. I'm saying, my lord, when you approach someone, you have to have a base, whether it's information from the source or a statement making certain allegations. All that I'm saying is that there was a reason for us to focus on Mr. Sibiya. So I'm not saying it's a source, because I'm now getting the impression as if I'm saying there's a source. There's a statement, my lord, in the docket which we disclosed to the defense again of Mr. Absolom Zongo, it's clearly implicating accused number 1 and number 2.
Manje sengithola ukuthi ummeli ikona-ke manje akushoyo ukuthi-ke ngithi sine-source noma kwakunomuntu owasitshela-ke kodwa engikushoyo-ke ukuthi kukhona nje okuba khona okukholayo noma i-information oba nayo-ke ezokholela kuloyo muntu loyo ukuthi uyokhulumisana naye-ke futhi-ke ngiyaphinda futhi-ke nanjengoba ngishilo ngaphambili ukuthi nalana-ke kwidokodo sikhona-ke i-statement sakhe u-Absalom Zungu abameli banolwazi lwaso leso statement leso yena-ke futhi oshoyo-ke ngokubandakanyeka kwakhe u-accused 1 and 2.
Absalom Zong, as you say, his statement has been discovered. Now, when accused number 1 was approached, he was not approached with that statement. Do you agree?
My lord, there was a basis. You don't approach suspect and show them the statement that person X. I mean, you'll be compromising witnesses and people's lives. Yeah, I mean, that's not how investigation is done. I'm simply saying there was a reason, there was a basis, and I'm mentioning this name because we disclosed the statement. If it wasn't disclosed, I was not even going to mention this name. But I'm simply answering counsel to say there was a base as to why he approached accused 1, because in that statement of this particular person, accused 1 and 2 are implicated as being involved specifically in the killing of Senzo Meyiwa.
Lana kumele uthi manje kodwa uma uyakena-ke number 1 awuyangakena uphethe istatement leso sikaZungu uthi awungeke ukwenze lokho uphenyo lenziwa ngaleyo ndlela manje-ke usuzobeka impilo yomuntu noma yabantu engcupheni uye kumsola ophethe istatement uthi ubani nobani bathi ngawe. Kodwa-ke esakwenza-ke ukuthi-ke nanjengoba ngisho-ke ukuthi siye sinaso isizathu esisibangela noma esisiholela ukuthi siye kubona siyokhuluma nabo ngoba amagama abo akhona uyawachaza lapha kulesa statement sakhe yena-ke uMr Zungu ekuyisona istatement abameli ababe naso ngaphambi kokuthi icala liqale.
All right. The basis for this question is will relate to the voluntariness and the element of the accused being free to make a statement. When Constable or when Sergeant Mohola, after she executed a warrant, ultimately accused number 1 was arrested. The approach was mainly on the execution of the warrant. Are you with me there? Because my question is mainly based on the elements that we need to prove under section 217, freely and voluntarily.
So we're dealing, I suppose, are we now on the confession part? Maybe just to understand,
No.
because Sergeant
No, it's part of the confession, it's part of the contestation of the 217(1)(a).
Yes. So
My question is, let me just rephrase it in order for us to understand. I'm saying, when the J50 was executed on the 30th of May 2020 by Sergeant Mkhula to accused number 1, the sole purpose was at that time hidden in relation to the death of Senzo Meyiwa to approach accused number 1 with the J50. I think Mr. 50.
I'm answering that, my lord.
Yes.
So first I was...
Now I'm saying, when she executed the J warrant, when the J50 warrant of arrest, she already had a prior knowledge of how accused number 1 is linked with the death of Senzo Meyiwa. That's prior knowledge I'm talking about.
Which is not a crime, my lord. So Sergeant Mohola is part of the investigation team. And I've indicated, my lord, that when this affidavit was disposed, we're seized with the docket. And suddenly we get a link that points us to 2 individuals. Analysis around these individuals were done, and these cases in relation to accused number 1 were picked up. Tembisa case, and it's not the only case. There is phosphorus cases where he was actually tried and finalized with a conviction, my lord. So when he was approached on the Tembisa matter, this was not the only warrant. There was a warrant of arrest insofar as the phosphorus case where he shot a female officer there, I don't mean to defame. And eventually after, there was no hidden agenda, and that is before the matter before this court.
Akukho okwakufihliwe lana nokuthi ke umkhula ke kukhona awayekwazi ke yebo ke lokho akusona ke icala ukuthi khona ke wayekwazi ngoba makuyiwa kuyena ke ngalo icala leli lasethembise kwangasilona kuphela ke ukhona lasephosphorus usewasho ke ukuthi kwakuyini ke lapho ude kayimisele nje ukuthi le phansi ke kodwa washo ukuthi ke kwagijulwa owesifazane khona lapho lalikhona ke futhi naleli ke kwakuwa namanye amacala kwangasilona nje kuphela leli elasethembisa noma iphosphorus kodwa namanye futhi amacala.
Furthermore, my lord, to assist on that, because counsel referred to section 217. Sergeant Mukhola, by the virtue of her rank, she's not a commissioned officer, and therefore not the justice of the peace. So she could not, I can't put her into that category. Perhaps that will apply when you speak to officers.
Futhi ke ngizwile ke ummeli ekhuluma ke ngayo section 217 ngokwesikhundla sakhe ke anaso ke emaphoyiseni uSergeant Mukhola ke akumbeki ke lokho la kuthiwa khona ke ama officers ke a commissioned manje uma ukhuluma ke ngama officers ke mhlambe ke ungakusho ke lokho hayi kuyena.
I was not relating 217 with Sergeant Mukhola. She's a sergeant. I'm well aware that she cannot take a confession, but for the first time, when she gave evidence that accused number 1 said something in relation to the death of Senzo Meyiwa. It was at the time she executed a J50 of 217/03/2019. That's the first time Sergeant Mukhola said to this court that accused number 1 said something like an admission, but she was well aware that she cannot take this other than informing Brigadier Kininda. Do you agree with me?
I agree with Finance Flores.
Ukuthi kwakungani ke aye ephosphorus ke bengichazile ke lokho uma ngiqala ngofakazi bami nobufakazi bami ke obuyinhloko ukuthi ke uma ke ngikhulumana nabo ke bangitshela ukuthi basendleleni ke eya khona ephosphorus beyokwenza uphenyo ngase ngibacela ukuthi ke asihlanganeni ke kuyona ipolice station yasephosphorus.
The reason why I'm asking this, Mr. Kininda or Brigadier Kininda, is that Sergeant Mukhola told the court that after they allegedly found the ammunition in his shack, they then accused number 1 directed them to a hostel in Vusumuzi. The purpose was to retrieve a firearm, or was to investigate if there was a firearm that accused number 1 might be.
I'm not sure what to say, my lord.
All right, let me say, after he was arrested and after the ammunition was found in his shack, then they took accused number 1 to a hostel to look for a firearm.
Well, my lord, I think Sergeant Mukhola can best deal with those matters. I mean, she was there, she questioned the accused, they know what they did.
Yes.
I think she'll be in a better position to deal with those issues.
Ukuthi ke babeya ke hostel yaseVusumuzi emuva kokuthi kutholwe ke inhlamvu babese beyobheka ke manje isibhamu uMukhola ke uyena ke wayekhona owaxoxa ke noma wakhulumisana nomsolo wakhe uyena ongaphendula ngcono lapho.
And going to so, oh, I thought the court is
Me, if I want to talk, I'll talk.
no, I heard the court
No.
with a funny sound.
You'll hear me when I want to talk, Mr. Ngomezo.
Yes. The purpose for going to phosphorus, it was not to do further investigations according to your evidence, which is compared to the evidence of Sergeant Mukhola,
No,
but was to look for the firearm in one of the hostels in phosphorus.
well, my lord, if that is what Sergeant Mukapasiti, that falls under investigation.
Uma
So we are saying the same thing.
mina nawe sikhuluma into eyodwa ke ngoba uma kuwukuthi amaphoyisa ayahamba nje khona lapha ayosesha bayobheka khona ke uma uthi wena bayobheka isibhamu uphenyo lolo.
Now I understand the meaning of investigation, and I don't want to be distorted in relation to the definition. My concern is that when he was taken to Phosphorus was to investigate other cases, which is new from what Sergeant Mukhola said. Sergeant Mukhola said, as they were preparing to go to Phosphorus, they received a call to say they must wait for you in Phosphorus police station.
As a God pleases, that is not.
Yeah.
Because to wait for them so that they wanted a backup to go to the hostel. That's what Constable Buthelezi said. To do what in the hostel, Constable Buthelezi. Constable Buthelezi Munareng for it, where Sergeant Mukhola and accused number 1 entered the hostel under their guide.
My Lord,
That is not correct.
It's the other way around. Let's understand the evidence. Otherwise, let's understand the evidence. After Sergeant Mukhola says they found that ammunition,
Yes.
his evidence is accused number 1 is the one who left the hostel where he said to us, we will find accused number 1, who informed her of certain admissions. And she says she excoriated her. Why didn't you tell us this before you were arrested now? You should have told us. No,
Yes.
I knew one day I'll account.
Yes.
Then she, because as you rightly say, she's not a 217. Officer phones the brigadier to say, hey, accused number 1 has just made certain admissions to me. I think you must come and consult with him.
In Phosphorus.
And that's when they stop going to the hostel to look for the firearm, because he instructs them, come to the police station in Phosphorus. That's how I get the evidence.
That's correct, my lord. It's the same I
Oh.
heard. But now I was relating the evidence of Constable Buthelezi,
Okay, fine.
because it came first before the evidence of Sergeant Mukhola.
Okay.
Because according to the evidence of Buthelezi, they ended up in Phosphorus. In Phosphorus, the discrepancy is that Constable Buthelezi led evidence which landed them in one of the in the hostels in Phosphorus. That's the difference between his evidence and the evidence of Sergeant Mukhola.
making some admissions, and they were on their way to Phosphorus for investigation. I then said, not to disturb, the route that they were taking. Let us meet at Phosphorus SAPS. That's how we found each other there with accused number 1.
Lana ke okwenzekayo ukuthi uma ke umhola ubuthelezi benikezwe ngokufakazi ke ngangekho enkantolo ngibaza ababusha, kodwa mina ngikushoyo ukuthi ke uma ngikhulumisana naye ke uSergeant Mukhola engitshela ke ukuthi kukhona ke okuthize okuvunywa ke uyena umsolo wokuqala. Base ngitshela ke ukuthi babe sendleleni eya ePhosphorus, ngabe sengithi ke angaphazamisi ke indlela yabo noma la baya khona, ngase ngithi ke asihlanganeni khona epolice station yase Phosphorus.
I understand everyone. Constable Buthelezi explained the rights to accused number 1. Sergeant Mukhola explained the rights, constitutional rights. When you arrived, when you had the chance to speak to accused number 1, you further explained the rights to accused number 1.
My Lord, I don't, perhaps it's not put into the correct context to say further. I was not there when those rights were given. I, as the person who was going to question him in relation to this matter, I'm aware of the rights that he must be aware, that he must take note of in terms of the Constitution. So I explained them to him for the first time.
Thank you.
Asengiqhubeka-ke mhlambe ke akusiyona-ke indlela yokuthi ngayisho-ke le mina kwakuwokokuqala-ke mina ukuthi ngangizokhuluma naye-ke ngikhuluma mayelana nale cala-ke so ngangazi-ke ukuthi waphi amalungelo engakufanele ngimtshele wona ukuthi awazi ngakwenza-ke lokho.
And I'm not saying, my Lord, there were no rights that were given. I'm saying to me, because I was encountering the accused for the first time. It's a procedure. That's how you cannot just ask someone in relation to an investigation that possibly makes that person a suspect or a person of interest without questioning them of their constitutional rights. That's not how it's done.
Angisho-ke ukuthi-ke babengamchazelanga-ke laba ayekhulumisane nabo ngaphambili-ke kodwa ngikhuluma ngami-ke manje ukuthi ngangizokhuluma naye-ke awukwazi-ke ukuthi vele ukhulume nje nomuntu-ke mhlawumbe ukhulume naye noma uzokhuluma naye-ke into engamenza ukuthi abe umsolwa ubese ungazeleki ngamalungelo akusiyona.
Constable Thelezi explained the rights, Mukhola explained the rights, and such rights were further explained by you to accused number one. That's how I wanted to put it. But there is evidence, as we have led it, one, in relation to the alleged admissions he has made at the police station in Fort Lawrence.
Yes, I'm not sure if I said I read. I didn't use the word.
No. You can delete it if you want to, but you explained it.
Yes.
It's a matter of how you...
And I've mentioned them. What rights did I give him?
Yes, I'm getting into the
not
rights.
reading them. Yes.
Yes.
That's correct.
Bese ngishilo ukuthi-ke amalungelo wona-ke ukumchazela noma ngasho futhi ukuthi waphi-ke engamchazi nemaphi engamchazela wona.
You are explaining the rights to accused number one at Fort Lawrence police station. Firstly, I would say amongst the rights that you have explained, a right to remain silent.
Yes, amongst them, my Lord.
Kumalungelo engamchazela wona-ke ilungelo-ke lokuthula.
A right against self-incrimination.
Correct, my Lord.
Nelungelo-ke lokuthi-ke ungakhulumi into ezokufaka-ke noma esho ukuthi uyambandakanyeka.
The rights or consequences of not remaining silent.
Yes, that if it does decide to say something that is incriminating, it can be used against him. That is correct, my Lord.
Nemiphumela-ke yokungathuli-ke ngamanye amagama-ke uma kunento oyikhulumayo ukuthi lokho okushoyo-ke kungasetshenziswa ngakwena.
The right to legal representative. If you don't have your own, you can get a state lawyer. If I
Correct,
put it
my
that way.
Ilungelo lommeli nokuthi uma-ke ukuthi-ke akwazi uyitholela ummeli umbuso ungakulekelela.
And to challenge any irregularities.
Well, first, the first one, my Lord, was a right for him to be detained in an environment that is suitable with human habitation.
Elinye-ke noma lokuqala kilelo kumchazela-ke ukuthi ufaneleke ukuthi-ke ugcinweke noma uvaleleke kwindawo-ke efanelekile-ke eyamhlana-ke nezimo zokuthi-ke umuntu ufanele avalelwe kwindawo enjena.
It's one of the rights. Sorry?
Yes, and then of course the right to challenge the legality of his arrest, and if he feels that it's unjust, that he should be released with immediate effect.
Futhi-ke nelungelo lokuthi-ke uma ubona-ke ukuthi indlela-ke oboshwe ngayo-ke noma ovalelwe ngayo-ke ayihambisani-ke nomthetho-ke ukuthi-ke ungakulwisa-ke noma ungakuphikisa-ke lokho uma kutholakala-ke ukuthi ngempela-ke awuboshiwe ngendlela efanelekile unelungelo lokuthi udedelwe.
Did you explain the right to be presumed innocent until proven guilty?
My Lord, I think we're not in a trial, with due respect. I didn't explain that right. I didn't think it was significant. At that time, he needed to know those rights that I've given him, and then indicate what he was dealing with the trial issues.
Manje-ke ilungelo lokuthi-ke ufanele-ke noma-ke ubhekwa-ke noma ubukwa nanjengomuntu-ke omsulwa-ke noma-ke ongenacala-ke kuze kube yisikhathi-ke laphona-ke inkantolo yona-ke ifinyela kwesinye isinqumo. Angisibonanga-ke isidingo sokuthi-ke lelo-ke ngichazeke ngoba-ke bengaqulwa cala-ke laphayana bekufanele nje ukuthi ngimchazele noma ngisho lana engiwashilo kuyena ebengathi nje cha ngifuna ummeli lapho-ke iyaphela-ke inkulumo yami naye ayisaqhubeki.
So
And my Lord, I think those rights are clearly defined in Section 35. You have a right of an accused person, a right of arrested person and a right of a detained person. There's a difference. When a person appears before court, is an accused person. The court will warn that person differently than what the police will do when they're arresting him for the first time on the street.
Futhi ke uma ubheka lamalungelo lana ke kunamalungelo ahlukene lana ke awukwazi ukuthi wahlanganiseke khona ke lo muntu ke oboshwayo umuntu owumsola ophambi kwenkantolo nomuntu ke futhi ovaleleke uma umuntu evela phambi kwenkantolo ummangalelo inkantolo ke yona ke izomexwayisa ngendlela ke eyehlukile nanje ngendlela iphoyisa uma limbopha estradini umuntu elizomxwayisa ngakhona.
So I telling the court that the right to be presumed innocent until proven guilty is a right explained during the course of the trial?
No, I'm saying for the purpose of the interview, we were not during the trial process. The purpose of what is it that he elects to do at that moment to take the investigation forward, those were the rights my Lord that were relevant. Because if he had said to me, I want an attorney, be it private or state, then you stop and proceed with those issues. If he says to me, like he said, no, I'm comfortable, I don't need an attorney, and then I need to speak to you, knowing the consequences of his responses, and that he was making such concession to a commissioned officer who is regarded also as a justice of the peace, you proceed. You cannot say now the trial stage. At that stage, this is the ground part, that's where you start.
Lana ke bekuseyi lana ke esisaqala khona ke la ummeli angibuza khona ke uma manje sesiya phambili ke uma bekuwukuthi wayishilo ke kumina ukuthi cha ufuna ummeli ngangeke siqhubeke ke sasizophela khona lapho kodwa ke manje ukuthi nje ngimchazele lawo malungelo lawo abese yaqoka ke noma uyakhetha ke ukuthi ufisa ukwenza kanjani noma ukuthini ke kodwa ke wangitshela ke mina ukuthi cha akamfuna ummeli futhi ke uyimisela ukuthi ke akhulumeke nami.
I understand the way you put it. A right to be presumed innocent in anticipation. Say for instance, accused number one, he made some sort of admissions which may have resulted in a confession of some sort. Do you understand?
He made a confession. The elements of the crime were all in there in what he told me, my Lord. I'm not sure if you say so.
No.
I viewed what he was telling me as a confession.
Lokho angitshela kona mina ke kwakugonyuluka ke ngoba konke ke nje okumayelana nokuphathelene neqala ke kwakukhona kuyona yonke le yanto awayengitshela yona.
Yes. If you are comfortable or you precisely understood the meaning of a confession and its requirements, hence we have to call a person capable of taking a confession. Is that so?
That is correct.
Kuyiqiniso ukuthi ke kuloka ngitshela kona ke bese manje ngezwe ukuthi yini ke manje lena iconfession ukonyuluka ukuvuma ila manje sengithatha isinqumo khona ukuthi manje angifoneleke umuntu ozongisiza ngokwenza khona lokho.
A person with such a wide experience in investigating cases, background of the law, there are certain things that to guard against when a person is making a confession. Do you know them?
I suppose the violation of their rights, my Lord, which I think I guarded against that. I'm not sure what counsel perhaps wants to say.
Angazi ukuthi yini ke ummeli afuna ukuyisho ke ngoba ke yebo uma kuukuthi umuntu uyakhuluma kukhona ke izinto fanele uyibhekeke enye ke ukucela phansi ke kwamalungelo akhe.
My Lord, with your leave, may I refer a witness in relation to my cross-examination to a particular provision
Yes.
in the criminal procedure. Do you have a copy of the criminal procedure? Section 219. Can you please read section 219 for me? 219.
Evidence of any admission made extrajudicially by any person in relation to the commission of an offense shall, if such admission does not constitute a confession of that offense and is proved to have been voluntarily made by that person be admissible in evidence against him in a criminal proceedings relating to that offense, provided that where the admission is made to a magistrate and reduced to writing by him, or is confirmed and reduced in writing in the presence of a magistrate, the admission shall, upon the mere production at the proceedings in question of the document in which the admission is contained. That's what it says.
Yes. There's something I missed. It didn't refer to. So are you not reading section 219, capital letter A?
Well, you said 219.
I said 219.1.
That's what I'm reading. It's 219, capital 9.
May I see that? I'm not referring to section 219, capital letter A.
No, 1. I'm reading
Yes.
capital 219.
1.
Yes, that's
Yes.
the one I'm reading. It relates to the magistrate.
Yeah.
It's a different grouping with the justice of the peace, my lord.
Yeah, all right.
It is 2191.
No. Say it's 219. Section 219. Can you check section 219 there?
Can I ask my lord that the council should just
Yeah,
highlight
maybe,
it?
yeah, you're right. Mr. Gomez will read it for you. You can ask
Or maybe
Mr.
read it,
Junior to
yeah,
read
so I
that,
can
yes.
read it.
Because the witness says he has read what you said he must read. Now you're saying no. Read 219.
There's a difference. There's a section 219 and a 219 capital A. I think what Mr. Mgomezulu wants the witness to read is 219, which reads no evidence against another person. I'm not sure that's the section that you wanted to read. And by the way, I'm not a junior. I was admitted before him.
When I use junior, I don't use it in terms of admission status. I use it in terms of appearing in this court. He is leading you. You may be senior, but he is leading you.
Yes, yes.
Mr. Nisili, am I correctly interpreting the status?
Yes, in that context, he's my senior here.
Okay, they're fine, but let's be serious.
Yes. But
Is that the correct section you want this witness
that's correct.
to answer on?
I'm relating to that section.
Just repeat it so
Yes. Just repeat it so that you get it.
It's section 219, and the title is Confession Not Admissible Against Another. And it reads, no confession made by any person shall be admissible in evidence against another person.
that. Okay, that's what. Okay, fine. You heard that, sir.
I've heard my lord.
Right.
You understood what was right. My question is, at the time when of what related to you, were you aware of this provision?
I was aware, but my lord, that provision does not talk about things that you must be cautioned of before. It talks about the confession made by one person that it cannot be used to another person. The only thing that I'm aware of is that the person must be aware of his constitutional rights and make a selection of what he wants to do before admissions or confessions can be taken. Now that section simply tells you that you can't use the confession of person A on person B if they are both suspects. That's the essence of what was read to me.
Lokho kodwa ufunda la kumina ke noma ke engikufundelwa ke ukuthi nje uma kuukuthi othize ukhulumile noma ugonyulukileke lokho akushilo akukhoneki noma kwazeke ukuthi kungasetshenziswa komunye awumsolwa kanye naye ikona nje lokho kodwa akhulumike ngamalungelo ukuthi kufanele ukuthi iqala ke kwenzeke nike kodwa akhuluma nje
It must be made free voluntarily without any undue influence. That's a complete. There's a difference, my lord.
kuhlukeke lokho ukuthi manje lokho uma umuntu ukwenza ke engaphoqelekile ke futhi ukhululekile nje kuphuma kuyena kuhlukile kulokho.
Now, please just focus on section 219. why I'm concerned about Section 219. For you to make a decision at that time when accused number one told you, you made a decision to call a competent somebody to take a confession. Having heard the contents of what he told you, you made a decision, a spontaneous decision, to call a person that can assist with the taking of the confession.
Yes, that's how the best practice, my lord, is done. I could have taken it myself, but it's normally preferred that someone independent should take such writing. That's how the best practice. That's how things are done all over the country.
Indlela ke kusetshenzwa ngayo ekwenziwa ngayo ke leyo ke ngangakuthatha ke noma ngikubhale ngokwami ke lokho awayekusho kodwa ke indlela ke ekuyiyona ukuthi ke kubizwe ke umuntu ongasiyona ke ingxenye yophenyo walelicala ingakho ke nami ke ngaxhumana ke nomuntu.
And my lord, I was not so what perhaps must be clear, there was no confession that was being used against accused number one. He was making confessions and arrangements were made for that confession to be taken down. So we're dealing with one confession. There's no other confession except the one he made to me and subsequently deduced in writing to Colonel Mboto.
Ayikho ke enye eyayenziwe la ekwakufakwa khona ke igama lakhe ke yilena ke i-confession lena umsolo oqala yena ke la wayekhuluma khona ke ngakwase ke kuthola ngenza ukuthi kutholakala umuntu yile eyabhalwa ke uyena uKolonel Mboto.
Brigadier Kininda, what you are answering me is not relating to the decision you took when after you listened to accused number one. You're not relating to that. Is that so?
Yes, and I did.
Yes.
I did
Number two.
give him his rights, my lord.
Number two, I'm concerned about if you know what are the elements or the requirement of Section 219.
My lord, the section that was read to me says you can't use a confession made by person A on person B. That's the essence of what was read to me, my lord.
Yeah, I hear you.
I'm not confused. I'm still on Section 219. I'm going to argue on Section 219 based on what, as the source of the first person you received the information from accused number one, which necessitated you to take this person to a relevant person who can take a confession from accused number one. There are safety measures comes to your attention, being a brigadier, to say what he is telling me is also involving other people in that confession. Do you understand now?
I understand, but I don't agree with the assertion counsel is telling me. My understanding of that proof, you can't spread it to accused number 2, 3, 4, and 5. That is the assertion. That is the essence of that code. In other words, you collect that evidence, that person is confessing, you will deal with that evidence if the court admits it, insofar as that person who made the confession. Not that you can't listen to it.
Lana ke ngiyamuzwa ummeli into ayishoyo ke kodwa ke lokho eqeda ufunda kumina manje uthi yebo lo muntu angakhuluma uyayenza ke le confession kodwa ke isetshenziswa kuyena kuphela ayisetshenziswa ku number 2 ku number 3 ku number 4 no ku number 5 kodwa ke uma sekuyukuthi manje inkantolo iyavuma ukuthi ilaleleke ila izosetshenziswa uyena.
That aspect I'll canvass it, my lord. I think it's appropriate time to answer.
What's the time now?
It's 3:30.
3:30.
Yes.
Yeah, your last question was?
I'll canvass it tomorrow and leave it for argument later. So the charge sheet is.
Yes, I am.
Okay. Okay, we adjourn until tomorrow at 10.